My name is Corey Lovato. As he just mentioned, I'm a managing attorney at the Arizona Center for Disability Law, and we'll be going over a lot of different laws, pretty much every law that would pertain to a service animal, or most of them anyway. For those of you who have service animals or are looking to get one, hopefully this will give you some good information. So the first thing that I want to touch on is just the distinction between service dogs or service animals and ESAs or emotional support animals. So a service animal or a service dog has a specific definition under the ADA and most of the other laws that we'll be going over. It's a dog that has been individually trained to do work or perform tasks for an individual with a disability. There are subtle differences between a few of the laws, but for the most part, that's pretty consistently the right definition, or the same definition, I should say. A few notes: that the tasks that the dog performs must be directly related to the person's disability, and this definition, as I just mentioned, that I recited for this slide, does come from the ADA, but there are a number of different laws that use a very substantially similar definition. An emotional support animal, on the other hand, doesn't have an official definition under the law. So people will typically make this distinction between a lot of different kind of assistance animals, let's say like service dogs or emotional support animals or therapy animals. And I just wanted to touch on this because I think it's important to note that the laws, or most of the relevant laws, they will define service animal, but they don't necessarily define all these other terms like therapy animal or emotional support animal. The one exception to that is the Fair Housing Act that we'll look at in a few minutes here. But basically an emotional support animal is any animal that provides comfort just by being with a person. They don't have to necessarily be trained to perform a specific job or task for a person with a disability. So an example of this would be maybe someone with autism could have an emotional support animal that they can go to and pet, say it's a dog, pet the dog or be with the dog, and it will help lessen the symptoms of their disability simply by being with the animal and having the animal with them, even though the animal has not necessarily been trained to perform a specific job or duty for that person's benefit. And again, it's not a specific legal term for an emotional support animal, but that's the term that I'm going to use in this presentation. Emotional support animal is basically just an animal that provides comfort by being with someone. So that would include like therapy animals and some of the other things that people typically think of. So here are the different laws that we'll be going over during this presentation. That these cover service dogs for the most part, and emotional support animals are mentioned, as I said, under one of these, the Fair Housing Act. So four main laws: the Americans with Disabilities Act, the Fair Housing Act, the Air Carriers Access Act, and then just some differences between federal law and Arizona law, because those first three are all federal law. And I also wanted to point out that the Americans with Disabilities Act has different titles, different sections basically, that apply to different areas. So Title I applies to employment, Title II is state and local government, and Title III is public accommodations. And public accommodations is basically just a term that means businesses that are open to the public. So think like restaurants, bowling alleys, doctor's offices, hospitals, all that stuff. I mean, taxi companies, pretty much any business that is open to the general public is going to be covered under Title III. I mention that just because the laws are different, obviously, between the ADA or the Fair Housing Act or the Air Carriers Access Act. All these different laws have slightly different rules when it comes to service animals, but even within the ADA, these different titles, the rules are different. So depending on the context, if you have a service dog and you want to bring it with you to work versus if you want to take it with you to like a baseball game, the rules are a little bit different. So I want to go over that as well. So different laws, different definitions of a service animal, as I mentioned. So the important thing, or the thing to touch on first, is if you remember a few slides back when I gave the service animal definition, or the service dog definition, it's like, where does that definition come from? I took that definition from Title II of the ADA, because that has the definition of a service dog and all the different rights and responsibilities that someone would have defined in an actual regulation, which is helpful. All these other laws either don't necessarily have the term service dog defined, or they have it defined in a guidance document that some executive agency has basically issued saying, hey, here's what we think a service dog is, or here's what we think an emotional support animal is. But it doesn't have the same sort of force of law that it would if it was included in the actual law, or even if like one of those agencies had written a regulation. But that being said, it is a pretty accepted definition, and it pretty accepted that a service animal is covered under all these laws. It's just that the definition is not necessarily hard and fast, like written into the law. So the one thing to notice here, I think that's kind of an outlier, or two outliers. One is that Title I of the ADA, which, if you go back to this slide, covers employment. That does not have an actual definition of a service dog anywhere in Title I. So if you're going to if you want to bring your service dog to work, or if you need to bring it with you as a reasonable accommodation, that's not something. There's no law in the ADA that says here's what a service dog is and here's when you can like take it to work. So we'll go into that a little bit as to why that is and how you go about getting a service animal at work. And then the Fair Housing Act is the other sort of outlier, that it does define a service dog, and it actually cites to the ADA when it is defining that. But the Fair Housing Act is more broad than these other laws. So I mentioned emotional support animals. The Fair Housing Act does cover emotional support animals, whereas these other laws don't. So that is just something to be aware of before we get to it, that the Fair Housing Act gives a definition of what's called an assistance animal, and that includes both emotional support animals and service animals within assistance animals, although it might be a little bit different depending on which one you have, just the analysis and how you go about getting one to live in your home with you. But we'll go over all that in a minute. So we'll start at the top with employment. Title I of the ADA. So the first thing that is worth noting is that there's no automatic right to have a service animal at work. And this is a little bit different. So think like, I haven't gone over Title III yet, but most people just kind of intuitively know, hey, if I want to go out to a restaurant or any other kind of business, say you want to go to the store, you want to go to Target or Walmart, do some shopping, go to the mall, that you have a right to have a service animal with you. For work, that's not necessarily the same. You can't say, well, I have this service animal and I have my job, therefore I have a right to bring my service animal with me to work. That may be the case. You may still have that right to bring the service animal with you to work, but it's not the same sort of automatic right that you would get as you're going into, say, a department store or something. Like you're going into a department store and you have a service dog, then you have a right to have that animal with you. It is instead granted as a reasonable accommodation at work. And this is a term that might be familiar to some of you. If it's not, no worries. We're going to go over it during this presentation. But it's essentially where you have to ask your employer for an accommodation, for a change in the rules, to say that, hey, I need to bring my service animal with me because of my disability. I have some disability-related need for it. So even though we have a rule at work that's no dogs in the office or whatever it is, I need an exception to that rule. That would be a reasonable accommodation. So that's how you go about doing it, getting it in employment. And again, since there's no service animal definition under Title I of the ADA that deals with employment, that means that it leaves a few questions open. So say you have an emotional support animal. Is that a reasonable accommodation at work? Maybe. You might be able to bring an emotional support animal to work. It's definitely going to be a harder argument to make rather than a trained service dog. But since there's no definition of service animal under Title I, it's basically whatever you can get an accommodation that is reasonable. So depending on the facts of someone's dog or their disability-related need and their job duties, all these different kind of things, those all kind of factor into that decision, but it's possible to get an emotional support animal as a reasonable accommodation at work. And then the other kind of question that I wanted to flag, since there's no definition, is it only limited to dogs? So I've been using the term service animal and service dog sort of interchangeably here, and that's because the ADA does define a service animal specifically as a dog. There's another exception for miniature horses, but for the most part it has to be a dog, and if not a dog, a miniature horse, but other animals, at least under the ADA, or the other titles of the ADA 2 and 3, do not qualify as service animals. But Title I, again, since it doesn't have a definition of a service animal, it's not necessarily limited to dogs. So if you have another animal that's trained to help you perform a task, that could possibly be a reasonable accommodation. And then the other thing is that the employers, not every employer is subject to the ADA. So there's certain criteria that the employer would have to meet before the ADA even applies. The biggest one is that they have to have 15 or more employees. And it's not necessarily just that. It gets a little more complicated that they have to have 15 or more employees for at least 20 calendar weeks. That's either this year or the previous year, the current year or the previous calendar year. I left that part out because it gets a little confusing, but basically they have to have more than 15 employees, and they have to have had more than 15 employees for 20 weeks or more, like at least 20 weeks.
Why
Sure.
15?
Why 15? It's a good question. That's just what they decided in the ADA, so that's written into the actual law. So I think they did it as a way to kind of ease the burden on small employers. So if there's an employer that only has, say, 10 employees, like it's a family-owned business or something like that, then that small business doesn't actually have to give someone a reasonable accommodation. It's not subject to the ADA at all, really. So they're not, like most employers are not, or cannot refuse to hire someone specifically because of a disability, because of the ADA. That's not necessarily true for a small employer like that. Anyway, so reasonable accommodations. So I mentioned that the way to get a dog at work is a reasonable accommodation, but what the heck is that? A reasonable accommodation, I got the official definition on here. I usually don't like to hit you with a wall of text, but just to read through it once. It's a modification or adjustment to a job, the work environment, or the way things are usually done during the hiring process. These modifications enable an individual with a disability to have an equal opportunity not only to get a job, but to successfully perform their job tasks to the same extent as people without disabilities. So a few things to break down here on that. First is that the reasonable accommodation obligation for an employer isn't necessarily limited to just their employees. If you need a reasonable modification in the hiring process, that also counts. That can be a reasonable modification. So if you have a service dog and you need to take it with you to a job interview, because a service dog is a medical device and maybe you can't go out and be out without your service dog, then you could ask for a reasonable accommodation to bring your service dog with you to a job interview. And as long as the employer is covered by the ADA, then that's a legitimate reasonable accommodation request. This obviously keeps going to the when you're hired and you have a job with the employer, that again, a modification or adjustment to a job or the work environment, bringing a dog into the job or bringing a dog into a work environment probably is an adjustment. And most employers generally would say, as a general rule, we don't let people bring their dogs with them to work. Like we don't let people bring pets with them to work. Service animal, of course, is not a pet. A service animal is a medical device. Hence the difference in treatment here with the reasonable accommodation. So service animals are generally a reasonable accommodation, but emotional support animals may not be. So we'll go over the reasonable accommodation process a little bit more here. We'll go over it a lot more in the next presentation that I'm giving on employment. So spoiler alert for anyone who wants to go to that one, that gets a lot more in depth. But here, I'm just going to give a real brief overview. So the best practices if you're requesting a reasonable accommodation, so say you have a service animal and you want to bring it to work, or you want to have it with you at the job interview, or whatever the case is, a few tips for best practices when you're requesting a reasonable accommodation. Number one, far and away the most important, have it written. I see a lot of people, or our office gets a lot of people who have asked for reasonable accommodations from their employer, but they did it just by going up to the supervisor and saying, hey, I was wondering if I could have X because of whatever the reason is that's related to my disability. So I was wondering if I could have a service animal because I have a certain disability. The problem with that is that obviously if it's written, there's no written record of it, right? So people's recollections could be different if everything is verbal. The employer, often I see this, that the employer will push back and say, well, no, so-and-so never asked us for this. You know, if we had known that they needed a service animal because of whatever with their disability, of course we would have said yes. But, you know, that's months later, and at that point, you know, it's kind of a he said, she said situation, whereas maybe someone came in and said, you know, I made this reasonable accommodation request. I asked my supervisor. She said, no, we don't have dogs in the office. And then the supervisor will claim, oh, you know, I didn't know it was a service dog. I thought it was just a dog, like a pet dog. And at that point, it just gets into, again, like a he said, she said argument, and there's no way to prove what was actually said. So far and away, most important thing, write it down. Use the words reasonable accommodation when you write that down. Like say, I am requesting a reasonable accommodation to have my dog come with me to work. Dated, make sure that the request has a date on it. That's another super important thing that a lot of people forget. And another problem with verbal requests, right? That you can say, oh, well, I asked my supervisor to have my dog at work, to bring my service dog to work. And then, you know, this maybe happened 6 months ago by the time you're talking to someone like me, like an attorney, because things have gone south. And then my next question is, okay, when did you make that request? And it's like, well, you know, it was a Wednesday, or it was maybe this day, it was, I don't really remember. So that can get really problematic, especially if it has to go in front of a court or an administrative body, if the date can't really be pinned down. Because, you know, that gets into, first of all, it can make it look less credible. Say like, well, you say that you asked whatever, but you can't even remember when you did it. There can be problems with the timeline as far as like how long the employer had to respond. So say the employer didn't respond for like 2 months, but then you come after them and say, hey, you didn't get back to me with my reasonable accommodation request, and they say, oh, well, you just did that 2 weeks ago. And you say, no, it was 2 months ago, but you know, you don't have a date on the accommodation request, so there's not really a way to show who was right. Anyway, so yeah, I would date the accommodation request. Make sure it's on there. If it's in an email, that works too. And then the third thing to, I guess, be aware of is that the employer can sometimes be entitled to documentation. And this is a subject that gets sensitive and can get kind of, this can get to be an issue between people requesting accommodations and employers. Because sometimes employers will ask for maybe a little bit more documentation than they're entitled to, or people will not be comfortable disclosing, you know, specifically their disability or all their disability-related needs for a service animal. Maybe they don't trust their employer to keep the information confidential. They are required to under the ADA, just as a side note. But you know, things happen. That's not always the case. I mean, you know, I understand that. But if the need is non-obvious, the employer can ask for documentation. So non-obvious, say you need a service animal because you have PTSD, and the service animal can like do a check. It can like notify you by say tapping your foot or something, coming up and licking your face if you're about to have some kind of episode. Maybe the dog can like run ahead and check around corners for people with PTSD if there's a blind corner. I've seen that because they can get triggered if they go around the corner and there's something unexpected there. So the dog will go up to the corner and, you know, check to see if anything's there and let them know if the coast is clear. But that's a non-obvious need for the dog. Like you can't look at someone and tell whether they have PTSD or not, right? However, if the need is obvious, then the documentation rules are a little different. If it's a non-obvious need, then the employer basically is entitled to enough documentation to show that you have a disability and that you have a disability-related need for the service animal. That doesn't necessarily mean that you need to disclose what the disability is. You could just have a doctor write a note and say, you know, my patient, I've seen this patient for X number of years or X number of months or whatever it is, and they have a disability that causes them to experience flashback episodes when they come up to a corner and something is unexpected there and it startles them. Therefore, they need a service animal to go perform a go check and mitigate that. So in that case, you haven't told the employer that the person has PTSD, but you have told them the disability-related need for the service animal and the task that it performs. So that would be enough. The employer doesn't necessarily have to know your exact diagnosis. They just have to know that you have some kind of qualifying disability and that the service animal will perform some kind of task to help with that.
So would it be like a neurologist or a neuropsychologist who makes that referral? I don't know.
No, it's a good.
What kind of doctor?
It's a good question. What kind of doctor? And really, it doesn't actually even have to be a doctor.
There's guidance on this on the EEOC website, and I believe it's linked. It may not be on the end of this slideshow, but I believe it's on the other one. Or if you Google EEOC service animal guidance, you should be able to find that, along with, I think they have a Q&A for like commonly asked questions about service animals. But yeah, doctor is usually the best kind of documentation if you don't want to get into any kind of arguments with the employer. But they can take documentation from other sources. So say it's a therapist. You know, it's not an MD, it's not a medical doctor, but your therapist is familiar with your mental health diagnosis, and a therapist could then write a note and say, you need a service animal, or my patient needs a service animal for whatever reason. Social workers have written notes. Sometimes a credible statement by the individual can, or at least in theory, be enough, although employers will generally push back on that, and it ends up kind of being an argument. But yeah, there isn't any rule that says a medical doctor or this particular type of medical doctor has to write a note. It's basically whoever is familiar with your disability and your disability-related needs for a service animal, so that that person can, you know, write down why it is that you would need the service animal at work as an accommodation. So once you make a reasonable accommodation request, that kicks off what's called the interactive process. So the interactive process is basically just a conversation between the employee and the employer about the accommodation. Or if not that accommodation, then maybe some alternative accommodation. So say you talk to your employer, you send your accommodation request to your employer, and you say, I have, you know, whatever condition, or maybe you don't say what the condition is, you just say, I have whatever effects that my service animal will help, and therefore I need my service animal to accompany me at work. And the employer comes back and says, okay, well, we don't know if we could do that. You know, there's whatever issues in the office, but what if instead we let you work from home? And when you're working from home, you can have the service animal with you. That would be an alternative accommodation, and that would work. I mean, it may work. I guess it depends on the needs of the individual, but if that would work, then that is a way to have the service animal stay with the individual, and for the individual to still do their job, assuming that that's possible to do remotely. So the employer in that case could say, okay, well, we're going to give you this alternative accommodation because we don't think that we can have the dog, a service dog, in the office. Accommodation, if you request an accommodation, it can't be either an undue burden, that should say or, undue burden or financial hardship on the employer. I left out one other reason, I guess, that they could deny it. It is on the next slide. It's a direct threat. Basically, if the dog is aggressive and it's biting people or something like that, then they can deny the accommodation on those grounds also. But speaking of reasons for denial, we can get into the analysis, kind of the process, like what happens once you request a reasonable accommodation. The initial burden is on the employee to show that the accommodation is reasonable, which is usually shown that it's just an ordinary accommodation request, right? The burden would then shift to the employer to show either is the accommodation unreasonable. So for some reason, is this an emotional support animal rather than a service animal? So say emotional support animals are less common, right? Like that's not necessarily an ordinary request. So the employer can say, well, it's unreasonable for that reason. And the employer can also argue that the accommodation, they can deny it because it's one of four things. Either an undue hardship, say it's an undue administrative burden, like it would take too much for them to set it up. It's a financial burden, so employers sometimes have to bear some sort of cost for implementing accommodations. Hard to say what that would be for a service animal. Maybe they have another employee who has allergies and they'd have to install like a new air filtration system and a bunch of other things that would bankrupt them. Or if it's a fundamental alteration, meaning basically a fundamental alteration to the job. So say your job is like working construction and you're like, well, I work the jackhammer, but I need to have my emotional support or my service dog with me. But the service dog can't work the jackhammer. And he's going to get scared about all the other construction that's going on. So everyone needs to be really quiet. And then the employer's going to come back and say, this is a construction job. It's loud. If you need us to work quietly, that's a fundamental alteration to what we're doing. So we're going to deny your accommodation on those grounds. And then fourth would be direct threat, which is kind of what I was saying. If the dog is aggressive, it's biting people, then they can deny the accommodation as a direct threat to the health and safety of other employees. So that's it for the Title I, the employment part. Again, if anyone would like to know more about employment, I'll go a little bit more in depth with that in the next presentation that I'm giving. A little plug for that, shameless plug. But with that, we'll move on to the Fair Housing Act. It's an easy one to follow up with because the Fair Housing Act also grants service animals and emotional support animals as a reasonable accommodation. The main difference between the Fair Housing Act and the ADA, or the employment part of the ADA, is that the Fair Housing Act recognizes assistance animals rather than service animals. So an assistance animal includes both service animals and emotional support animals. It's not limited solely to dogs. And again, it must be granted as a reasonable accommodation. So it's more broad, basically, than just having a dog that is a service animal, which makes sense if it's somewhere that you live. The rules are a little bit more relaxed. So who does the Fair Housing Act apply to? Well, it covers tenants, homeowners, and prospective homeowners, which is worth noting. And it also covers family members and people with disabilities who are associated with those people. So say you have a brother with a service dog who wants to come over to your apartment, and the apartment complex says, well, we have a no dog rule. We're not going to allow the service dog here. That doesn't fly. You could ask them for a reasonable accommodation to have your brother's service dog come and visit you. And under the Fair Housing Act, that is something that's a legit reasonable accommodation request. Sure.
If they say no animals on the premises, do you have to request for that dog to come onto the property before the family member brings it over, or can they just come at any time?
You do have to make the reasonable accommodation request before they can come over. So that is one difference between like the Fair Housing Act and say Title III of the ADA, where you're going to a business. Like you don't need the business's permission to bring your service animal with you to where you're going. Yeah.
Someone's apartment, call the property manager before you go there.
If there's a no dogs rule or a no pet rule, and then you're bringing a service dog, then you would have to request it as a reasonable accommodation. That gets a little more complicated if it's like something that's open to the public, like some apartment complexes say we'll have like a clubhouse and they open that up to the public for whatever event. In that case, the clubhouse would be functioning more as like more under Title III, so it'd be covered by Title III. But if it's a private residence and they have a no dog rule, then you would have to ask for an accommodation.
So if it's a private residence and you decide to get a service animal and they want to charge you a monthly dog fee or whatever, is that waivable?
They can't. Yeah, they're not allowed to do that. That is covered in the Fair Housing Act.
So but you would ask the landlord for that reasonable accommodation and say we're going to get a service animal. Don't charge us the extra $100 a month or whatever.
Yes, that's exactly right. You would just ask to have the pet fee waived and just explain that this isn't a pet. This is a service dog. And also worth noting that the Fair Housing Act applies to dwellings or housing providers, and it's not always super intuitive like who that is, right? So you would think a landlord or whoever owns the property, that's one, but also HOAs, those can have fairly repressive rules depending on which HOA you have. Homeless shelters, group homes, nursing homes, dorms, pretty much anywhere that someone treats as their actual home is covered by the Fair Housing Act. And also worth noting that it applies to common areas as well. So they can't say, okay, well, we'll let you have your service animal in your home, but you just can't bring him to the clubhouse, or you can't bring him to the pool. We'll see that a lot. And I mean, fair enough that they're not allowed to, or they are allowed to say you can't have the dog swimming in the pool. That's fine. But to have the dog like on deck, helping someone, then that they can't deny that. Or they can't say it's unsanitary because if the dog gets in the pool or something like that, if the dog isn't getting in the pool. I've seen HOAs make that argument before, that like just having a dog in the pool area is unsanitary, and that doesn't fly. Quick note on reasonable accommodations. So the type of assistance animal, if it's a service dog that would fit under those definitions, the ADA definitions, that's generally a reasonable accommodation. An emotional support animal may or may not be. They generally are for the Fair Housing Act. I say may or may not because sometimes emotional support animals, they're not always dogs and they're not always common. And there's a guidance document from HUD that is linked at the end of the slideshow that goes through this whole analysis really well if you want to know how to request a reasonable accommodation from your housing provider. But it's basically if it's a more exotic animal, that can be a little bit harder to make the argument. But if it's like an emotional support dog or cat, or there are a few other, a few other things that are listed, then that's a lot easier. They still have to, if the housing provider is going to deny that accommodation request, they still have to make one of those other arguments, that it's an undue burden or a financial burden or a direct threat or something like that. As far as documentation goes, is the housing provider entitled to documentation? If it's an obvious disability, then no. So again, if it's someone who's blind who has a seeing eye dog, the housing provider can't say, I need documentation of your disability to make sure that you're not pulling one over on me. Like, it's an obvious disability, no, they're not allowed to ask for documentation. But if it's a non-obvious disability, then yes, and it's pretty much the same as the employment context. TBI is tricky because sometimes it's obvious and sometimes not. If someone has a TBI, like if someone has a TBI and it's affected their mobility to the point where they're like they use a wheelchair or something like that, and you can readily observe that someone is in a wheelchair or has some kind of orthopedic impairment, then that would be an obvious disability. But there are plenty of people out there with TBIs, and looking at them, you would never know. It depends on the specific circumstances then. For an emotional support animal, do you need documentation? Pretty much yes, because you need to show a disability-related need for the emotional support animal. So even if someone has an obvious disability, it's generally not really readily apparent how an emotional support animal would help. So say someone in a wheelchair has a service dog, and the service dog, you just ask them what task can it be trained to perform, which comes up a bit later on here. They tell you the task that the service dog can perform, and that's it. They're good to go. But for an emotional support animal, that's not trained to do individual tasks, right? That's an untrained animal that assists just by kind of having its presence. So there typically is the housing provider will have a right to ask for documentation for that. The interactive process, worth noting, is not necessarily required under the Fair Housing Act, but housing providers, if they're just going to deny it and not participate in the interactive process, they're kind of doing that at their own risk. Because if they end up improperly denying an accommodation request, you can later file a complaint or a lawsuit or something and say, look, I tried to work with them. They wouldn't participate in the interactive process. And the court or HUD or wherever you go is going to say, oh, yeah, it doesn't look good for them, because they just kind of, you're right. You tried and they didn't really work with you. And then again, no fees for assistance animals, kind of the question that we got earlier. Not allowed to charge fees for someone to have an assistance animal. And the reasonable accommodation analysis under the Fair Housing Act should look very familiar. First, the employee has to show that it's reasonable. Then this should say housing provider versus the employee-employer. But the burden is on the tenant. Is the accommodation reasonable? And then the burden is on the housing provider. Is it unreasonable? And then the housing provider, again, can make one of those same arguments of undue hardship, financial burden, fundamental alteration, or direct threat. So Titles 2 and 3 of the ADA, next up. We'll start with Title 2. That covers state and local government services, and the actual language is all services, programs, or activities of a state or local government. That applies to both places and services owned or provided by a state and local government. So think like courthouses, museums, city hall, parks, also city buses, schools, when you're going to vote. All that stuff that's run by a state or local government is covered under Title II of the ADA. Worth noting, it does not apply to volunteer programs or to employment. Employment, again, is still covered by Title I for these places. And it does not apply to the federal government. They actually have their own separate law that is not in this particular presentation, but it's called the Rehabilitation Act, and it basically functions the same as the ADA. So if you're a federal employee or in a federal program, worth noting that you do still have those rights. It's just not necessarily the ADA. It's a different law. Public accommodations. Again, these are places that offer goods and services, i.e. businesses, that are open to the public. So again, a couple examples: restaurants, bars, stores, bowling alleys, hospitals and doctors' offices. Those are important ones that sometimes get forgotten, but those are just businesses. Those are open to the public. So a hospital or a doctor's office has got to allow your service dog in. There are some different rules for hospitals. If it's some area that needs to be maintained for sanitation purposes, then they can deny the service dog access to those areas. So specifically think like a surgery room or something like that. They can say the service dog is not allowed in there. But if it's just like, you're going into the lobby or something of the ER, or, you're in just a regular part of the hospital where other people are allowed to go, and it doesn't have to be kept sterile, then the service dog is allowed to go there. And then again, does not apply to employment, that's covered under Title I. So a few differences between Title II and Title III. I'm handling these together because they're largely similar. They have the same service animal definition, but Title II does have some extra protections. So Title II, if you remember back to the definitions of service animals, Title II is the one that has the actual regulation that defines what a service animal is and all the different things you can do with the service animal and all that. Title III doesn't have that. And then Title II also has some extra, has a provision in that regulation for miniature horses. That does apply to Title III also. It's just not in the regulation. It's in a guidance document. But essentially, if you have a miniature horse that will function as a service animal, then that is generally okay under Title II and Title III, although it's a little bit different of an analysis.
So now we all want a miniature horse.
I know. They actually do. I thought it was crazy, but I learned a little bit about them. They actually do some really crazy, cool stuff. Anyway. One other difference that is worth noting is that Title III does have a state law equivalent, and Title II mostly doesn't. When it comes to service animals, at least it doesn't. So Title III has a state law called the Arizonans with Disabilities Act, and it actually it applies to same thing as Title III, public accommodations, and it actually goes a little bit further than Title III, because normally if you are going to sue someone for basically infringing on your rights under either Title II or Title III, then at least under the federal law, Title II, you're allowed to recover damages. But Title III, if you're just suing a business, you're only allowed to get what's called injunctive relief, which is basically a court order saying that the business has to comply with the law. So the business has to allow service animals in, but you're not allowed to sue them for money damages. But since we're in Arizona, there is a state law that allows people to sue for money damages under entities that would normally be covered under Title III. So there's not really a difference for us here in Arizona, but I wanted to flag that because it's worth noting that if you ever leave or run into problems in another state, then at least on the federal level, those laws that apply everywhere, the ADA, you can't sue for money under Title III, but you can under Title II. So state and local governments, you could sue for money, but businesses, you can't, at least for this type of thing. Service animal definition. Again, a dog that has been individually trained to do work or perform tasks for an individual with a disability. The dog has to be trained to take up specific action when it needs to perform, to assist a person with a disability. This doesn't cover emotional support animals. It doesn't cover miniature horses in the actual definition, but again, there is a guidance document that has been issued, and Title II does have this in the regulation that miniature horses are okay. It's just a little bit different analysis. Like they have to consider like 5 different factors rather than just kind of getting an automatic okay like they would for a service dog. It also has to be under the control of the handler. So does that mean leashed? Not necessarily. It doesn't necessarily have to be on a leash, but it does have to be under the control of the person who's handling the dog. So that can be under control by voice commands or an electronic like an e-collar. As long as the dog isn't, going crazy and whatever, this basically overrides any local state leash laws, state or local leash laws. So run into that also. As a general rule, service animals have to be allowed to accompany people with disabilities in any area of the facility that the public is otherwise allowed to go, with certain exceptions, again, like for hospitals, clean rooms, kitchens, things like that, where there's a sanitation issue. But other than that, for the most part, the service dog has to go anywhere that you're allowed to go. And very much worth noting that individuals can train their own service animals. There's no official service animal registration or database that is either required or even exists under the ADA. Those exist by other entities, by third parties that will say, if you register your dog here, it's a registered service animal. And there's nothing stopping you from doing that, and it may help you to prove it if someone says that, it's not a real service animal, but there's nothing in the ADA that says you have to do that. you have a right to train your own service dog. You don't have to like specifically register it somewhere. As long as it's trained and is doing its job, you're good to go. Permissible questions. These are big. So if you have a service dog and you go into any of these entities, like any Title II or Title III entity, which is most of the places that people will go with their service dogs, there are only two questions that they're allowed to ask you. Number one, is this a dog a service animal required because of a disability? You say yes. Number two, what work or task has the dog been trained to perform? So then you say, oh, well, he picks things up off the ground because I can't bend down to get him. Or, he goes and does a go check around the corner or something like that. That's it. That's all they're allowed to ask. They're not allowed to ask what your disability is or specific questions about your disability. They're not allowed to require medical documentation or a special ID card. They're not allowed to say the dog has to be wearing a vest. The dog does not have to be wearing a vest. Nothing under the ADA requires a service animal to be wearing one of those service animal vests. And they're not allowed to ask for training documentation for the dog. See that a lot too, because again, people have a right to train their own dogs. Oh yeah, and they also cannot ask that the dog demonstrate its ability to perform the work or task that it does. You can tell them what it is, but some of the stuff, like say you have diabetes and you're like, say, I'm diabetic, my dog alerts me when my blood sugar is low, which is a thing that service animals can do. They can actually smell when someone's blood sugar is low and alert them. You can't like demonstrate that on demand. So they're not allowed to have the dog demonstrate whatever it's supposed to do. When can a service animal be asked to leave? Couple limited circumstances. The dog is out of control and the handler does not take effective action to control it. Both those things have to happen. Two, the dog is not housebroken, self-explanatory. If the dog is going in public, then, or at least where it's not supposed to, then they can ask you to leave for that reason. But if they do, then the staff, wherever you are, must offer you the opportunity to obtain the goods or services without the animal being there. So say the dog, you're at the store and they ask you to leave because your dog is being unruly. You can go and like leave your dog, hopefully, not in the car, don't do that. We live in Arizona, we all know not to do that. Say you live it with a friend or a family member or someone outside, and then you go back into the store and say, okay, well, I'm just gonna go get stuff without the service dog. They have to let you into the store to get the stuff without the service dog. They can't say, no, you're not allowed because we just threw you out. Reasons that are not good enough to ask the animal to leave. Number one, allergies and fear of dogs. That happens, see that a lot. Cannot deny a service animal entry because of allergies or fear of dogs. Food is being sold or prepared, like restaurants or grocery stores were open to the public. You can't ban a service animal from those places. You could ban a service animal from like the kitchen, but that's different. The public isn't generally, going through the kitchen of a restaurant or going like behind the counter at the butcher in the grocery store or something like that. And again, since this is a federal law, state and local health codes, even if they say that dogs are not allowed in like a grocery store, which is common, if it's a service dog, it can go. Places where no pets are allowed, state and local leash laws, breed restrictions, all of those are a no-go, not good enough reasons to deny a service animal. Service animals can be any breed. Leash laws, kind of how we went over a minute ago, don't apply to service animals. And no pets allowed also doesn't apply because a service animal isn't a pet.
What about buffets?
Buffets, good question.
Food is out in the open the majority of the time, so
Yeah,
it's just a restaurant, in my opinion, right?
it's just a restaurant. Dog can go with you to a buffet. If the dog is, jumping up and eating the food out of the buffet, that's a different story. But, if the dog is just with you at the buffet, then yeah, that's completely fine. The Air Carriers Access Act, one of the last laws that we're going to get to, we're getting towards the end here. This is one of my least favorite laws for a lot of different reasons, but service animals in particular, they just actually redid the regulations in December of 2020 and made a few big significant changes. So first of all, they defined a service animal, and it's basically the same definition as the other laws. It means a dog, regardless of breed or type, that is individually trained to do work or perform tasks for the benefit of a qualified individual with a disability. Notably, this means that emotional support animals are not covered by the Air Carriers Access Act. And this law applies basically, as it kind of sounds, to airlines. So if you're flying with a dog, it used to be that you could fly with an emotional support animal, but as of December 2020, There's no federal rule saying or federal law saying that you have to be allowed to fly with your emotional support animal. Airlines may still allow you to do it, but that's up to them individually. Yes.
But they said personal support animal.
It was emotional.
What is an emotional support animal?
Oh, okay. Emotional support animal is a dog that has not necessarily, or not necessarily a dog. It's an animal that hasn't necessarily been individually trained to do work or perform tasks, but it's a dog or an animal. Excuse me, I keep going back to the dog thing. It's an animal that may assist someone simply by its presence. So the example that I used earlier was, say, if someone has autism and having a cat around. We'll use a cat for the sake of an example. Having a cat around to pet can help mitigate the effects of the person's autism and their disability, even though the cat isn't necessarily trained to do anything. Yeah, those are not covered by the Air Carriers Access Act anymore. So you don't have no one has an automatic right to fly with an emotional support animal. But a dog, a service dog, is covered. And worth noting that this specifically says that animal species other than dogs are not service animals. So no miniature horses on the plane. Airlines, the part that drives me crazy about this is the other things that airlines may also require. They may require, number one, for the service animals to be leashed, even if they don't normally get leashed, or even, in the ADA, if the leash, for example, would interfere with someone's ability to kind of control the dog. So say someone's in a wheelchair and they say, I can't use the leash because it will get tangled in the chair wheels or, whatever. The airlines can say, tough, this needs to be leashed while it's on the plane.
Just when it's on the plane, when before boarding onto the plane, they can be.
Yes. That's different. Yeah. The Air Carriers Access Act only applies to like the actual plane and the immediate kind of loading area at the airport. So the places that airline controls. The rest of the airport is not subject to the Air Carriers Access Act. That would be probably Title II or Title III of the ADA, depending on who owns the airport. 2 service animals max per individual while flying, and the service animal has to fit within the foot space on the plane. So if you have like a big, I don't know, a giant breed of dog that is your emotional support or your service animal, and it won't fit on the plane, they can deny you service. And they're not required to accommodate anyone by upgrading their seats. So you can't say, well, if you put me in first class and I'll have more leg room, the airline can say, well, sure, if you want to pay for first class, but we're not going to move you up there on our own. And they have a right to do that. And then the other big thing that's covered by the Air Carriers Access Act that they can do now is they can ask you to fill out a form before flying with your service animal. And the thing that really drives me crazy about the form is that there is one line on there that says like, where was the dog trained? And if, again, you can train the dog yourself, that's still okay under the Air Carriers Access Act, but it's not really readily apparent on this form. And I'm sure that, I can foresee a lot of people filling out the form and putting like they self-train the dog and then handing it to whoever works for the airline who is not trained in this kind of thing and says, well, there's a line here, there's a box to check that says, where did you get the dog trained? And you say that you just did it yourself. That doesn't sound good enough to me, so I'm not going to let you fly. I'm sure that's going to happen. They're not allowed to do that. If you have, everyone has a right to train their own service dog, take it with them on a plane. But yeah, that form can be required up to 24 hours, I believe, before the flight, as long as you haven't booked it within that time. So be aware of that. That's the one form that's just basically attesting to the dog as a service dog and its training and its your disability related need for it. And then there's a second form if you're flying over 8 hours that the airlines can require that basically attests to the dog's ability to either hold it for that long, to not go on the plane, not relieve itself on the plane, or to relieve itself in a sanitary manner on the plane so that it can go the full 8-hour flight. So those 2 forms are pretty unique to the Air Carriers Access Act. Like none of these other laws require any kind of form, right? Like you don't need to fill out a form to take your dog to the movies or your service dog to the movies or whatever. But for flying, then as of December 2020, they can require that. The Rehab Act, just wanted to touch on that really quickly. This applies to the federal government and federal contractors I put it kind of in the middle of this Air Carriers Access Act because a lot of the times this will come up with airports. A lot of airports are owned by the federal government. They're on federal land. So federal workers, contractors, executive agencies, all that stuff, they're all covered by the Rehab Act. And also applies to entities that receive federal money. So again, an airport would be covered most likely by the Rehab Act, maybe also by Title III or Title II, depending on circumstances. But I put that in here just to kind of illustrate the difference between what's covered by the Air Carriers Access Act and what's covered by a different law, in this case, the Rehabilitation Act. So again, the documentation that airlines can require, I got a little ahead of myself on this. Number one, the Department of Transportation form attesting to the animal's health, behavior, and training. That's the one that I was saying drives me crazy. And then number two, just attesting that the animal can hold it and can go on a flight for 8 or more hours. The only time that they require that is when it's 8 or more hours. The airlines can require the forms 48 hours in advance, not 24. Looks like I misspoke earlier. But 48 hours in advance. If you book a flight within 48 hours, they can there's an exception to that. But if you book the flight, say, I don't know, a couple weeks in advance, then the airline can say, you need to get us this form 48 hours in advance. And if you get it to us shorter than that, say 45 hours in advance, we can deny you entry. And unfortunately, that's allowed now as of these revisions in 2020. Yes?
Other than saying my dog can train to go on a pad, how do you prove that? You just say it can do it?
You just say it can do it. You don't have to prove it. You just have to sign the form attesting it. And again, that's also only if the flight is 8 or more hours. But yeah, you just would fill out the form and tell them, it's fine, the dog can do it. And it's the same kind of thing as asking the dog to perform its task. Like, they can't ask that you demonstrate it, but if you are filling out the form attesting to it, then that's enough.
Thanks for that question, because I was wondering myself, how do you have a dog go to an airport and go to the bathroom? Where do they go? I mean, it's like,
Yeah.
Some airlines have like areas for service animals to.
oh, really?
Yeah.
Yeah, depending on the airport or the airline or whatever. Some do have service animal relief spots, which are great, but not everywhere.
But so the general thing is they're trained to go on the pad.
Yes. Or they're trained to, some people can bring pads with them that the dog can go on if there's no spot.
If a disabled person has to clean up after the dog, how do they do that?
Yeah, that's up to, the person with the disability to manage.
Figure that out.
Yeah. But so they can require those two documents, but they can't require excessive, other documents other than that. So they can't require like documentation of your disability. And then again, they can't require registration of the service animal. Even though that first form does have a spot that, a box to check next to a line that says like, what training has this animal undergone? They can't require registration.
So, excuse me,
Sure.
did you just read that link?
I would recommend writing that you train the dog yourself. If it asks like on that spot, just like self-trained, and then you could add a brief description, like 20 hours per week for 3 months or whatever it was, and then ongoing training, say like 30 minutes a day. Just to add some kind of description there. But yeah, if there's no, if you train the dog yourself, there's not going to be an organization like that. This is what drives me crazy about it, is it specifically says like, where was the dog trained, and asks for like a phone number and contact info for that place. And you don't have to have it professionally trained. You can train the dog yourself. So I would recommend just writing as much detail in there as you can, just so they know. And then if they want to argue with you about it, you have a right to file a complaint against them with the Department of Transportation. But I realize that doesn't really help you, like when you're in the moment and they're saying you can't get on your plane, which is why this law drives me crazy. But yeah, that's pretty much the world that we have to live with now.
Okay, thank you, sir.
Sure.
Do you have to buy a seat for the dog?
No, you don't have to buy a seat for the dog. It does just have to be able to fit in the thing in front of you, the leg room or whatever it is, the bulkhead.
So it can't be sitting on the aisle, obviously.
No, dog can't be out in the aisle.
So if you have a lab, it's kind of too big of a dog to be putting in front of you.
Yeah, it depends. It depends on the airline. I mean, if you're in like the front seats, maybe you could fit it in there. But yeah, I mean, a lot of those other airline seats, if you're further back, it gets pretty crowded, and it can be tough to fit a lab in there. Yeah. Yeah. So when can airlines deny transport to a service dog? Couple of different circumstances. If it violates the safety requirements, for example, too large of a dog, or they can't accommodate in the cabin, so the dog can't be in the aisle because that would be a safety hazard, and that would also make it so that they wouldn't be able to perform like the drink services and things like that. If the dog poses a direct threat to the health and safety of others, so kind of the same as before, dog can't be aggressive, can't be biting people. If it causes a significant disruption in the cabin or at the airport gate, that's not really defined, but I mean, generally, I think that's understood to be like barking and, not listening to the handler if the handler tries to calm the dog down or tells the dog to stop. If the dog is prohibited from entering the destination, U.S. territory, or foreign country. So this is an interesting one, that if you're flying somewhere that the airline can't verify that the dog is going to be allowed to get out. So say you're flying to, I don't know, pick a country, Scotland. And I don't know anything about Scotland's service animal laws. They're not even a country. They're a country within a country. They're the UK. Say you're going to the UK. Dug myself in a hole here. Anyway, you get to the UK and they say, we don't recognize service animals here, so we're not going to let you off with the service dog. If the airline knows that in advance, they can say, we're not going to let you on the flight to go to Scotland because they're not going to let you off once you get there because they don't recognize service dogs in Scotland. Again, I'm just making something up. I have no idea what Scotland thinks about service dogs. They're probably fine.
Isn't it just good due diligence?
Yes. Yes. It's good due diligence for the person to know that stuff ahead of time for sure. And they're probably realistically doing you a favor because you're going to get to the destination and be like, I can't leave anyway. But just, as an FYI, they are allowed to deny service for that. Or the last reason that I hate, if the airline requires the completed service animal forms and the individual did not provide the forms. The big reason I really don't like this is because this rule is new and a lot of people are not necessarily aware of it. Especially people who've had service animals for a while and been flying with them, because you've never had forms before. There's no other law that requires forms to have a service dog. This is just kind of the outlier. But yes, if you don't fill out those forms and the airline requires it, they are allowed to deny transport to the service dog. And then a couple notes to finish up here quickly about Arizona state law. Normally, service animals in training are not covered by the ADA. Or any of these laws really, except maybe the Fair Housing Act. But Arizona does have a state law saying that service animals in training are allowed in public accommodations, so places that would be covered by Title III, essentially businesses that are open to the public. It's got to be with a trainer or a person with a disability, but if it's a service animal in training, then yeah, it can go in. It also defines service animal as any dog or miniature horse, so they're good under state law. And again, the money damages are allowed for public accommodations who violate Title III. Although there is some other stuff, there's a 30-day waiting provision for parking lots and physical alterations. I throw that in here just because it's covered under, it's a provision under the law, but it doesn't really apply to service animals. Fake service animals in public accommodations. I think a lot of people have probably heard about this in Arizona, that there is a law, state law, saying that a person who fraudulently misrepresents an animal as a service animal is subject to a civil penalty. It can be anything up to $250 for each violation. So someone's basically has a fake service animal, they're not allowed to do that, to take it somewhere in Arizona. And then another kind of weird quirk to throw in here is that a zoo or wild animal park may prohibit a service animal, including even a guide dog for someone who's blind, from any area of the zoo or wild animal park where that service animal may come in direct contact with the animals contained there. So that's a weird state law provision that I just kind of wanted to flag in case anyone's going to the zoo, or I don't know where else that would even apply with the wild animal park, where you'd be running into wild animals, but just something to know that if the service dog is going to come in direct contact, I know some zoos have like peacocks that are wandering around or something like that, that they could deny entry to the service animal on those grounds. And there is a state law that covers that. Butterfly World. Yeah, see, I don't know if the dog, I don't know if I would believe him on that one. Anyway, complaint options. And this is not lawsuit. I'm not talking about a lawsuit here. I'm talking about just filing an administrative complaint with an executive agency because some entity is discriminated against you. So for Title I, that's the EEOC, the Equal Employment Opportunity Commission. They handle any kind of employment-related issues. Title II would be the U.S. Department of Justice. Same with Title III. That's like the government's law firm, basically. So they would handle those. Worth noting that the DOJ, the Department of Justice, doesn't have to look into complaints. They have discretion as to whether they want to, whereas like the EEOC or these other ones have to. The Department of Housing and Urban Development, HUD, handles complaints under the Fair Housing Act. And then the Department of Transportation handles complaints for the Air Carriers Access Act. And it's worth noting that these other laws, you also have an option to file a lawsuit. But for the Air Carriers Access Act, you do not have an option to file a lawsuit. You can't sue an airline for wrongfully denying you the service with your service dog. The only thing you can do is file a complaint with the Department of Transportation. That's the only remedy that you have. All these other laws, though, if you want to file an actual lawsuit, you can go right ahead. You have that right. You just also have a right to file a complaint with an executive agency that doesn't really cost you anything, whereas lawsuits are expensive. Lawyers are expensive. And then the three with asterisks, so Title I, Title III, and the Fair Housing Act, are also covered by the Arizona Attorney General's office. They have an Office for Civil Rights Division, and that's a state agency, obviously, the Arizona Attorney General's office. So they cover those laws because those particular laws, those federal laws, have state law counterparts. And so the AG's office will look over any kind of law that has a state law counterpart. And if you file with a complaint with the Arizona Attorney General's office, it will dual file a federal complaint with whatever the agency is. So say you think that your employer discriminated against you by not letting you have your service animal, so you file a complaint with the Attorney General's office. That would actually file two complaints. It would file one with the Attorney General's office, a second one with EEOC, and then EEOC will typically just defer to the Attorney General and say, okay, we're going to let them handle this and do the investigation and things like that. But you do have complaints with both entities open. And then a couple resources here. This HUD Assistance Animal Guidance, if you're at any point looking to get an assistance animal or a service dog to live with you, I would very much recommend looking up that assistance animal guidance because that really goes step by step how to make that accommodation request and when they can deny it, when they should approve it and things like that. And you can show that to the housing provider and say, look, like I did X, Y, and Z. You're giving me this reason, for denial, and that doesn't compute with what's in this HUD guidance or something like that. And that can be really, really helpful to get just kind of the rules set up so that everyone knows. Some frequently asked questions about service animals. I think I had kind of mentioned that earlier. In the ADA, that's more, that's Title II and Title III, that FAQ. ADA.gov has some service animal stuff. Job Accommodation Network. I didn't touch on this earlier, but Job Accommodation Network, or JAN, is a website that is run by the Department of Justice, the DOJ, and basically has a list of reasonable accommodations that you can ask for at work. So you can search like by disability type, you can search by like job duties, you can search by a lot of different things to find ideas for reasonable accommodations. So that's helpful. They have a kind of an overview of service animals in the workplace, but anyone who's looking for any type of reasonable accommodation at work, that's a hugely helpful website. There's an FAQ from the Department of Transportation for all the new rules for flying with service animals. And then, of course, that final service animal rule that's under the Department of Transportation. That one is long because it has all the commentary and everything in it, but the rule itself is fairly short. But that actual document, that last one, has all of their kind of reasoning and things behind it. And if you go in there, that's where it says that you can train your own service dog to fly with you. So if any airline ever gives you problems with that, that's where to find the answer to that. It's in that DOT animal rule. But again, it's like buried in, I think, at least 100 pages of stuff. It's on page like 60 something. So then just a little about ACDL, where I work. We're a public interest law firm and the designated protection and advocacy system for people with disabilities in Arizona. Basically, there's one of those in every state, so we're the Arizona one, every state and U.S. territory. We assist people with disabilities to promote and protect their legal rights to independence, justice, and equality. Offices in Phoenix, Tucson, and Flagstaff. We've recently opened that one. I guess I have to update my slide. But you can visit our website, azdisabilitylaw.org. If you have like service animal issues, we do also provide representation for people for things like that. We can't guarantee that we're going to be able to help for any particular issue that we have because we're a nonprofit, so everything depends on our availability and our resources at that particular time. But we do stuff like this fairly regularly, service animal type issues. So FYI, if you're having any issues, feel free to reach out and file an intake and see if we are able to assist. And then you can also follow us on social media for a little bit more information.